We're going to get started. Good afternoon, everyone. I'd like to welcome you to the Harvard Law School Book Talk for How to Interpret the Constitution by Cass Sunstein. My name is Leslie Diana Jones, and I'm the Associate Director for the Law Library, and we're glad you all could attend. Before we get started, a little housekeeping. Make sure you turn off your devices or put them on silent mode so we're not interrupted, because this is going to be an exciting talk. If you'd like to get a print copy of this book from the Harvard Coop, or check it out, or you can check it out from the library. You can also get a discount if you want the copy, because I know you all want to add it to your library. So you can get a discount from the publisher, Princeton University Press, and you'll get a 20% discount if you use the code SUN20. I'd like to thank the Dean's Office for their generous support of the Faculty Book Talk series, as well as my colleagues, Teresa Knapp, Christine Park, Juan Andres Fuentes, Rachel Parker, Mariko Hanshuku, Debbie Ginsberg, Leah Prescott, and Maya Bergamasco for their assistance in putting this all together. I know if you've registered for the lunch, you'll get that in the back. So I think that's being taken care of. So today, we're joined by our author, Cass Sunstein, and the panelists, Steven Pinker and Richard Fallon, Jr. Cass Sunstein is the Robert Walmsley University professor, founder and director of the program on behavioral economics and public policy here at Harvard Law School. He teaches administrative law and behavioral economics and is currently working on a variety of projects involving the regulatory state, sludge, defined to include paperwork and similar burdens, fake news, and freedom of speech. Our panelist, Steven Pinker, is the Johnstone Family Professor of Psychology at Harvard University, where he is an experimental cognitive psychologist and a popular writer on language, mind, and human nature. Professor Pinker is currently doing research on a diverse array of topics in psychology, including the role of common knowledge, where two or more people know that the others know what they know. Well, that was a tongue twister. And I said it. In language and other social phenomena, historical and recent trends in violence and their explanation, and the psycholinguistics of good writing and other projects. We also have Richard Fallon, Jr., who is the Story Professor of Law at Harvard Law School and affiliate professor in the Government Department. And he has written extensively about constitutional law and federal courts law. He is the author of a number of books, including The Nature of Constitutional Rights, Law and Legitimacy in the Supreme Court, and The Dynamic Constitution. So without much ado, I'll turn it over to the speakers for our discussion, and then afterwards we will have time for a Q&A. Thank you.
Great. Thank you for that. Thank you for coming. We have a little bit of an unusual format in the sense that I'm carrying a keyboard so that I can see the slides. You'll see them without carrying a keyboard, but if you want a little keyboard, we actually can hand them out just so I don't feel lonely as keyboard guy. Okay, so this is a passionate book. Here's an idea just to note, just to say, and to plant a flag. There's a possible approach to constitutional law. Let's call it experiments in living constitutionalism. And let's call that approach one that values individual freedom, such that if people in Missouri get to have very different practices from people in Connecticut, that's really fine, such that freedom of speech is robust, compulsory unification of opinion achieves only the unanimity of the graveyard, said Robert Jackson, Sir Robert Jackson. I think he was very great. Freedom of religion is on experiments of living grounds, ample, goes well beyond an understanding of the founding generation. Personal privacy is a really protected interest, including freedom from surveillance and including privacy with respect to sex and reproduction. So let's just plant that flag as an idea. It's maybe 6 parts mischief and 4 parts proposal, but I want to put it as a candidate. Okay, this is a book of some passion. It's a little low key, but I hope the passion emerges from the little pages. And it's passionate because it has a target. The target is a claim that an approach to constitutional law, by an approach I mean a theory of constitutional interpretation, is compulsory, that there's choicelessness in it, and those who deviate from the preferred choice are deviating from the Constitution itself. The claim of choicelessness with respect to a theory of interpretation is sociologically really interesting. It's not promising in principle, and the main theme of the book is exactly that. The only question I say to the question, what theory of constitutional interpretation should we embrace? And there are reasonable candidates, like more than 3, is what would make our constitutional order better rather than worse. You can see this, though this isn't mentioned in the book, as doing for constitutional interpretation what William James of Harvard did for truth. Whether we should be pragmatic with respect to truth, this humble lawyer has no view, but the humble lawyer says this is what we should do for theories of constitutional interpretation. This is the only game in town. That means that fixed points will matter, where fixed points are understood as the commitments that each of us, you, find yourself least willing to give up with respect to constitutional law. So if you believe, for example, that it would be an abomination if our constitutional order permitted racial segregation, that's going to be really important to you in deciding what will make our constitutional order better rather than worse, and that will be central to your choice of a theory of interpretation. You might yield on that if you find 7 compelling reasons to do that, but you will be reluctant, I believe, to yield on that, and that's honorable. If you think that a constitutional order that allows criminalization of same-sex marriage, same-sex relations, let's bracket marriage for a moment, same-sex relations, is barbaric, then that will count for you powerfully in the direction of supporting a theory of interpretation that outlaws state efforts to forbid same-sex relations. Different people, it should be clear, and thank you all for coming in. We're going to be very repetitive in these remarks, so you haven't missed a thing. Sorry, those of you who were here before. Be prepared to hear repetition. The idea is different people will have different fixed points. And this is a way of saying that John Rawls' idea that in thinking about justice, we try to reach reflective equilibrium, meaning we try to put our judgments in order, so that if there's a theory of justice that entails the legitimacy of slavery, we're going to be reluctant to accept it. Whatever we think of Rawls' approach to political philosophy, and I'll do a little bit more to clarify that, I say that's what we need to use, and actually disparate judges are using it for constitutional law. Okay, for those of you who aren't studying now or haven't studied over the summer constitutional theory, here's just a very quick effort to give a sense of the candidates. These are part of our legal culture. Many people, in fact, almost everyone, is a semantic originalist, meaning that the semantic meaning of the Constitution's words is binding. So if the word executive power came in 2040 to mean a new kind of energy that emits no greenhouse gases and that indeed takes greenhouse gases away, that's executive power. we would not think that executive power is vested in a president of the United States under Article 2, Section 1. So take semantic originalism, emphasizing the original semantic meaning of terms, as an idea and an extremely appealing idea. The words domestic violence are in the Constitution. They can't mean violence within the home. They meant something different as a matter of semantics. Okay, then there's public meaning originalism, which Justice Thomas and Justice Barrett and Justice Gorsuch are drawn to. Cool originalist kids tend to like this these days. That's thicker than semantic originalism because it uses contextual enrichment. Original expectations originalism was popular once. The cool kids no longer think it. They're the really badly dressed people in the corner to whom no one wants to talk, but they're committed nonetheless. And they believe that the original expectations are decisive. There's an idea that Justice Ruth Bader Ginsburg was drawn to. We should interpret the Constitution so as to reinforce democratic processes. So premium on the right to vote, premium on freedom of speech. That is a view. Justice Breyer also actually defended a version of that democracy reinforcement. There are some people who believe in moral readings. That is, that if you have a term like equal protection, you should be faithful to the semantic meaning, but cast it in the best moral light. So with the freedom of speech, there's a view, common law constitutionalism, which suggests that judges build up cases over incremental decisions, going one at a time, and that's maybe not theory-laden particularly, but it's our system. And Professor Vermeule has defended the idea of common good constitutionalism. I'm not sure if this is a familiar concept. It's relatively novel, at least as a theory, in American constitutional law, not necessarily novel as a practice, which says we should build on roughly long-standing ideas about what the common good is, and those are the source of constitutional meaning, and that's thicker and richer than originalism. Okay, there are some incomplete theories. Theorism means, Thayer taught here, means uphold everything if you possibly can. It's a very recessive approach to judicial review. Burkeanism says build on traditions. Chief Justice Roberts sometimes likes that. And for my sins, I've been known to admire minimalism, which says avoid deep theories and avoid broad rulings. That is also an incomplete theory. It's just what you should do given your other theory. You could be an originalist and a minimalist. You could be a moral reader and a minimalist. So minimalism is a partial theory. Okay, there's a view that the oath to follow the Constitution, which judges and public officials generally take, must be originalists. That is an argument with some traction. It's pretty harsh. It says that, let's say, Justice Frankfurter and Justice Marshall, Thurgood and possibly John, violated their oath of office. That's pretty severe to say. The problem is the Constitution doesn't contain instructions for its own interpretation. So to say the Constitution embeds originalism is to say something that might be right, but it's not something that the Constitution itself says. Semantic originalism maybe follows from the oath to follow this Constitution, but the other theories are outside of the Constitution, external to it, and can't be identified with it. And this is kind of a major component of the argument I'm making right now, that the identification of the Constitution with any theory of how to interpret it requires some normative argument, and it's not something that you could read off the Constitution itself. It's noteworthy that James Madison, when he was young, seemed to repudiate originalism pretty severely. And when he was old, he kind of liked originalism. He seemed to endorse originalism, maybe because he was part of the founding generation and he wanted them to stick to his view. The fact that Madison young deviated from Madison old at least makes it challenging to say that one of them was being unfaithful to the Constitution rather than the two had divergent views about the appropriate theory of it. Okay, you could believe in moral readings, like the freedom of speech should include protection of dissent or not. That's a view that isn't forbidden by the Constitution. It doesn't ignore the Constitution. It tries to identify its meaning. If you dislike moral readings, you might worry the judges will be immoral readers. Think of abortion, go one way or the other, whatever your view is. You might be nervous that the judge's moral infestation would misfire. And you might want a kind of second-order moral reading that would cabin the judge's own capacity to give first-order moral readings. You might say judges should presume everything's valid, so as not, that would be a second-order moral reading maybe, Thayer's view. Or you might do something else to cabin moral readings. Okay, here's Rawls on reflective equilibrium. There are some questions which we feel must be answered in a certain way. Here's a fantastic sentence from a recent excellent book that is originalist that says, "We do not believe that adopting the original meaning of the 14th Amendment as a whole would lead to results that differ radically from those that current doctrine would produce. Far from it." Let's put that sentence in bold font and scream it from the rooftops, because it's a revealing suggestion by a team of originalists, a two-person team, that originalism isn't going to make the United States of America radically different from what it is now. Far from it. They find it important to say that as a way, I think, of acknowledging that if a theory of interpretation wreaks havoc with freedom of speech, equal protection of the laws, and due process, then people will be extremely reluctant to follow it. I say good for them that they are on the train of reflective equilibrium, at least in that sentence. Okay, here's some possible fixed points, provisional fixed points you might have, and by you I mean you. That is the only person whose fixed points matters for purposes of your judgment is you. Though they're provisional, you might decide my fixed point I've rethought when I encounter other fixed points and theories. It might be that the power of judicial review exists, Marbury. It might be that school segregation can't be done by states. It might mean that abortion is protected. It might mean that abortion isn't protected. It might mean that the individual right to possess guns is safeguarded, or it might mean the opposite. It might mean, and I really hope it does, that the speech protective rulings of current law are steady and not vulnerable, given a theory of interpretation. And the question is, what happens to these things? Okay, resistance, this is a reference to Star Trek, forgive that. Resistance to the theory I'm suggesting is Borg-like futile. So in moral and political philosophy, so too here, in choosing among theories, we can't possibly ignore or refuse to attend to fixed points, even if they're subject to revision. For each of us, a judgment has to be made about what the fixed points are, how exactly fixed they are, and about when or another approach would endanger them. I hope Professor Fallon is sneezing a little bit because he's reading my mind right now, which is he was there first. So the identification of reflective equilibrium as a foundation for choice of theory of interpretation, I think I got there independently and late, but I probably read him and forgot. So he gets the credit if the theory is good. If it's bad, well, he probably discovered that too, and I didn't see it. Okay, the suddenly doubtful validity of provisional fixed points is a problem. It might not be decisive. If your theory of interpretation means that the federal government can discriminate on the basis of race and sex, that might be the end of that theory for you. Or you might think, I want to keep talking. I don't like that at all, but I might in the end be willing to bite that particular bullet. We have to do some assessing. So here's some just illustrative notes of what I think. The Dobbs case embraces due process traditionalism. If this is shorthand, the case overruling Roe against Wade basically says rights are protected as such under the Due Process Clause if and only if they are sanctified by tradition. I say that endangers too much in the way of privacy. Whatever you think about Roe against Wade, the theory itself would have put too much in the way of privacy in the toilet. Public meaning originalism, I say, would also endanger too much. It would mean our free speech principle gets really, really little. It would mean our protection against race and sex discrimination also start getting truncated terribly. If I'm wrong on those projections about public meaning originalism, then the argument for public meaning originalism suddenly becomes less vulnerable. So everything turns on what it would entail. For freedom of speech and the power of Congress and various others, these are notations, basically gestures toward these as fixed points for us. Okay, history hasn't stopped. Why did I put that on a slide? That's too, what is that? I hate the person who put that on a slide. It's too obvious, but it's true, so I don't hate that person that much. It would be shocking if we don't see more rulings like, and think of your favorites. Stakes are high here, yes? It might be about privacy, it might be about equality, it might be about poverty, it might be about crime, it might be any number of things. It would be shocking if we don't see more of those, and past is prologue, and what kind of prologue is our theory writing? So with respect to experiments in living constitutionalism, we have a few things that follow. And the suggestion is that this might make the suggested, at least, approach for consideration maybe 2 parts mischief and 8 parts proposal. And then we just have to look at it and see what constitutional universe it would produce. The proposal that the book ultimately makes is a cautious bet on an open future, meaning a cautious bet on a non-frozen, non-Thayerian, non-originalist future. And if this is not a persuasive bet, the burden of the argument is less make that bet, then don't be fooled by the claim that any particular theory of constitutional interpretation is required. Instead, think what kind of constitutional order would the proposed theory of constitutional interpretation yield? That's the only game in town. Thanks.
Thank you. I'd like to start by just expressing my appreciation for Professor Sunstein. Cass's very thought-provoking, sophisticated, and fair-minded book. Those of you who read it will see that there are obviously positions he disagrees with, but strives to present them respectfully, citing John Stuart Mill. Those who are not familiar with the opposing viewpoint know little of their own. So the backdrop, I think, is pretty obvious. There have been many cases where a number of observers feel that the courts have worked backwards from the outcome or the interpretation that they favor for various reasons, political, tribal, personal, and retroactively invoke the theory of constitutional interpretation that vindicates whatever they wanted to be true in the first place, in cognitive psychology known as motivated reasoning. And I take it that what Cass argues for is a sort of sophisticated version that would say that that's actually okay, that there are these fixed positions, they can change over time, they can vary, but the best theory of constitutional interpretation is one that does not do violence to conclusions which we clearly would find abhorrent. If your theory of constitutional interpretation says that segregated schools are okay, something's wrong with your theory of constitutional interpretation. And that the reason that this isn't just motivated reasoning is that it applies at multiple levels, from specific outcomes to the process itself and the very basis of why we have a constitution. Now, because of this, at least that's my reading of Cass's argument, he's obviously more sympathetic to the schools of constitutional interpretation that allow for some flexibility, some change to the morality, the democratic preservation against the kind of family of schools that would include originalism and textualism and intentionalism and so on. By the way, an aside is that from someone who's not a legal scholar, for decades I always thought that there was this school of constitutional interpretation called strict constructionism, sometimes contrasted with judicial activism, and I was kind of surprised at not being enlightened as to what this was. There's no section on strict constructionism. It's not even in the index. It seems to be some melange of textualism, originalism, and related doctrines. But perhaps Cass will want to say a couple of words about why it's not there. But even with and clearly Cass is not so sympathetic to the more what I naively and simplistically think of as the strict constructionist family of schools like textualism and originalism. But I'd like to make a somewhat stronger case for it than I saw in the book, in the spirit of steel manning the position that you disagree with, and have Cass respond to this steel man. The takeoff point is a kind of an aside a sarcastic aside that in the book, that it would be a stunning coincidence if the Constitution as understood in, say, 1792 or 1871 turned out to match the convictions of a political party in 2022, that being, of course, the Republican Party. But let me make a case where perhaps it's not a coincidence, that there is actually a coherent line of thought in the kind of Burkean conservative tradition that would connect the various strands of conservative thought, and that is what Thomas Sowell in A Conflict of Visions calls the tragic vision or the constrained vision of human nature, namely that humans are permanently saddled with cognitive and moral flaws, a theme that is, of course, familiar from many of Cass's writings, from the literature in cognitive psychology on judgment and decision-making, all the fallacies and biases that we're vulnerable to, and that because of that, societies should try to remove any claim to omniscience, infallibility, even grand foresight. That the reason that a Burkean conservative would favor free market is that no central planner is wise enough to direct an entire economy. Better just to have some rules of exchange and let millions of people make the decisions locally on a distributed basis. That criminal justice should focus on deterrence rather than rehabilitation, because none of us can engineer human nature well enough to actually change what's in the human heart. And by extension, the law should be as algorithmic as possible. There should be because judges themselves are human, subject to all of the moral flaws like my side reasoning and confirmation bias and tribalism, that we should not put the fate of citizens in the hand of capricious and self-interested interpreters. That most obviously it's an abomination if a person is convicted of a crime that wasn't a crime when they committed the act, that you can't capriciously flip the legal order and have a system of justice, and that institutions that take many years to build up shouldn't have the ground pulled out from under them by sudden shifts in the legal order. So this is why I'll challenge Cass as to why toward the end of the book, it says no algorithms here in capital letters. There is a well-known and highly robust phenomenon in cognitive psychology going back to the 1950s, which Cass himself has written about, on statistical versus clinical decision-making. And the upshot of that research is if you pit the predictive power of a human expert against a simple algorithm, just a regression formula from the 1950s, the algorithm always wins. In fact, the human with the algorithm does worse than the algorithm alone. And so the question is why no algorithms, given that the alternative is flawed human interpreters and judges? Now, there is Cass appeals a number of times to something that I fervently believe in, namely that there is such a thing as an arc of justice, namely that there is such a thing as moral progress. I myself have written 2 books arguing that that is the case, but it doesn't necessarily mean that the engine of justice, if you'll pardon the mixed metaphor, has to come from constitutional interpretation. The alternative is change the Constitution or write new legislation. Don't try to improve morality by the subjective interpretation of a bunch of flawed people. And in this regard, and one other question that I have for Cass, I notice what is an anomalous characterization of the book's thesis. Some might even call it a Freudian slip, that the book flap says that Professor Sunstein argues that the only way to choose a approach to interpreting the Constitution is to ask whether it would change American life for the better or worse. Now, in fact, I didn't find that in the book. I mean, there is makes the constitutional order better or worse. That's not the same as life. And in fact, that itself almost seems a little circular. A little more substantive is the claim that the theory of interpretation we should embrace is one that leads to a reflective equilibrium that does not do violence to our fixed points. That's a bit more specific. That's very different from doing whatever makes life better or worse, because the Burkean, Sowellian, classical conservative response to that is, who is the omniscient genius who knows how to make life better or worse? You've got to be a little more specific than that. You've got to have predictable laws that ordinary citizens know how to follow or not. And a quote from Oliver Wendell Holmes makes that clear. To improve conditions of life is the main thing, but how in the devil can I tell whether I am not pulling it down more in some other place? Therefore, he concluded, my job is to see that the game is played according to the rules, whether I like them or not. And then if the arc of justice is ascended not necessarily through subjective constitutional interpretation, but through, say, constitutional amendment or legislation. Now, I think there's an obvious answer, namely that the process of amending the Constitution is notoriously, I mean, clunky would be an understatement. It's almost impossible. Our colleague Jill Lepore recently wrote about that. In which case, is the argument in the book actually that ideally we should just change the Constitution to implement our changing understanding of morality? But since that's just, for practical reasons, so hard, as a kind of kludge or stopgap, we'll have to have flexible interpretation because we're kind of stuck with the Constitution and it is so difficult to change it. Okay, I will stop there.
So thank you for inviting me. Congratulations to Cass on this wonderful, wonderful book. It's fair-minded, as Professor Pinker says. If you want to know what the field of play in constitutional interpretation looks like today, this would be as good a place to start as any that I can imagine. And I also want to say that I agree with Cass about what is in many ways the most important point in the book, and that is in choosing a constitutional theory, anybody ought to be, practically has to be sensitive to consequences. Cass says that that's the only game in town, is to be thinking about consequences when you choose a constitutional theory. And so I agree with that. And so now I want you, every one of you in this room, to imagine that you've just been named to be a justice of the Supreme Court. And so you're going to be choosing a constitutional theory. And one of the things that's very striking in the way Cass sets up his position, here's in the idea that you need a theory. So why do you need a theory? If what you're concerned about is good consequences, why not just bounce from case to case and choose whatever result you think would yield the best consequences in that case? So that's a question that I want to bracket for the moment, but I want to come back to. And so then, with that question bracketed, let's focus on Cass's preferred way of getting to the theory, which is what he describes as a reflective equilibrium method, where you sort of bounce back and forth between your case case-by-case intuitions about what would be a good outcome and what would be the best theory to adopt. And if there is disunity, if there's some inability to get those things to line up, then you'll need to adjust your position either about what the right outcome is or about what the right theory is. And so then the question would be, well, why would you want to do that? Why would you want to be trying to find reflective equilibrium? And if you're trying to find reflective equilibrium, let's imagine you're trying to find reflective equilibrium. If this is the right way to do it, let's imagine somebody who thinks just like Adolf Hitler is trying to reach reflective equilibrium, and then imagine that there is somebody short of Hitler, but somebody that you know has very different views from yours about what would be the appropriate fixed points or what would be the appropriate case-by-case outcomes. And Cass says, well, you should all be trying to find reflective equilibrium. That's the only game in town. And so then I would say, well, why would you be trying to do that? And I can think of at least three reasons. One might be that it's just psychologically uncomfortable not to have your case-by-case intuitions aligning with your theoretical views. So you want to put yourself psychologically at ease. That's a possibility, but that doesn't seem like a very good basis on which to be trying to develop a constitutional theory. Now, when John Rawls, the famous moral and political philosopher, first employed the reflective equilibrium method as the method of finding appropriate principles of justice, Rawls thought that the purpose of reflective equilibrium was to find the truth with a capital T about what justice requires. And in order to make the reflective equilibrium method a reliable one for arriving at truth with a capital T, Rawls set a lot of conditions on how this had to be done. He had the famous thought experiment of the veil of ignorance, all sorts of things that you can't know when you're making your decisions, and so forth. But then Rawls actually, even in the area of moral and political philosophy, seemed to come to believe that this was actually not a reliable method of arriving at truth with a capital T, and that for purposes of achieving principles of political governance, it was a mistake to be trying to do that. And so then Rawls decided that when people are trying to seek reflective equilibrium with respect to moral and political philosophy, I should have said, when people are trying to find reflective equilibrium with respect to political philosophy, what they should be aiming at is to find principles that every reasonable person in their society would recognize as being legitimate. And by legitimate, Rawls meant something short of being correct, short of being the right ones, but principles that he thought other reasonable people in the society ought to be willing to recognize as a basis for organizing the society in light of the very great benefits of achieving a rule of law under a constitution that everybody thinks of as a fair basis for decision, understanding that there will be disagreements about how particular cases ought to come out. So Cass says we should all be trying to pursue reflective equilibrium. You, Adolf Hitler, me, and somebody who thinks very differently about constitutional law from the way that you do. So now what I want to say, if we're doing reflective equilibrium, why are we doing it? Not, I say, to try to get mere psychological comfort. That's not going to be a good basis for how to interpret the Constitution. probably not truth with a capital T. Do you really believe that there's a sort of truth with a capital T about how the Constitution ought to be interpreted? What would it mean to say that there was truth with the capital T? And so then I would say if there's a reason to want to do reflective equilibrium, it's with the purpose of thinking that trying to do reflective equilibrium can be done, should be done in such a way that decision-making pursuant to the theory of constitutional interpretation that somebody arrives at is one that ought to command the respect of ideally all other reasonable people in the society, which was what Rawls had in mind when he talked about legitimacy. So then in order to do that, in order to have any ghost of a chance of arriving at a theory that you will expect to command the respect of other reasonable people in the society, surely there have to be some constraints on the way that you can do reflective equilibrium. The great risk is garbage in, garbage out. There's got to be some constraints, some way of ruling out some possible beliefs that somebody could be working with trying to achieve reflective equilibrium and say, no, that just won't do. And so that was the later Rawls's project. And I would say if we want to carry reflective equilibrium methodology over to constitutional interpretation, that's what we ought to be doing. So with respect to Hitler, Hitler's just out. Hitler isn't reasonable. Garbage in, garbage out. Hitler wants to seek reflective equilibrium. He's entitled to do that, but it's not going to yield a method of constitutional interpretation that anybody ought to respect. What about the person who thinks very differently about constitutional issues from the way that you do? Don't there have to be some restrictions on what that person can be taking into account as his or her fixed points, such that you're going to respect the conclusion that that person's exercise in reflective equilibrium yields? I think so. And if so, then when you're seeking reflective equilibrium, you've got to be doing it, I think, if you want to get the kind of constitutional theory that will yield the work that we want done. You've got to be prepared to make some accommodations in what you will take to be your fixed points or what you will take to be acceptable methodologies in light of what you know or could expect that other reasonable people in our society would demand in order for them to be prepared to accede to somebody's decisions pursuant to that theory as legitimate ones. So where does this leave me? It's a wonderful, wonderful, wonderful book, but it doesn't quite come all the way fully to grips. We're supposed to say something critical, you know, that's the etiquette in this sort of things, with what I think are the two biggest questions in some ways. And one of them is, why is reflective equilibrium the right method? I say it's got to be aimed at legitimacy somehow, but Cass doesn't quite say that. And then the second thing I wish he'd said a little bit more about, and maybe he will in the period that's coming up, is a little bit more about the constraints that a chooser would have to accept in order to achieve the kind of reflective equilibrium that ought to lead other people to say, you know, I don't really agree, but I respect that. That's a legitimate way to go about doing these things.
Thank you so much. If we could give our panelists one more hand of applause. So now we have some time for audience Q&A. So if you have a question for our speakers, please raise your hand and my colleague Christine will come find you. We will try to get to as many questions as we can.
Hi, thanks, panelists. What, if at all, does the fact that the Constitution itself intended itself to be amended through a process have on a decision of whether any of these theories of interpretation is better or worse?
None, zero. If that's unclear, nada, zed. Okay, connects with Steve's point that whether an interpretation is an amendment or not depends on our theory of interpretation. So if we understand the Equal Protection Clause to forbid, let's say, discrimination on the basis of sex when it wasn't originally so understood, is that an amendment? It depends on the theory of interpretation. So if you take the word 35 for the president to mean 2, that would be an amendment. But yes, you'd have to be very creative to have a theory of interpretations such that 35 would be 2. Some of you know math, so maybe I just said something very naive. Bracketing that point, all of the reasonable candidates, Thayerism, uphold basically everything, do moral readings, focus on the original meaning, focus on the original intention, reinforce democracy. None of that amends the Constitution unless we stipulate that one of those theories is right in a very strong sense, in which case being an originalist would turn out to be amending the Constitution because you're not doing the moral reading. And then the originalist would say to the moral reader, no, you're amending the Constitution. You're not following the original understanding. And then we're in the domain of name calling, and nothing good is going to follow from that. I'll say a little bit, shall I, about the amazing comments. Thank you both. First, for coming at all, and second, equally for the fantastic substantive points. So to Steve's points, this is not a fighting book along one dimension. If you've agreed with everything yours truly and said, Galileo-like, nonetheless, I'm an originalist, good for you. You could be an originalist on this account of how to choose a theory of interpretation. But I hope this isn't obscure, but the reason you would be an originalist is you think that makes our constitutional order as good as it can possibly be, and the other approaches turn it into soup or into horror. Then you'd have to defend that view, that originalism produces non-soup and not horror compared to the alternative. That's the domain of the argument. If you read the book and say, I want an algorithm constitution, you can choose your algorithm. Maybe it's that, the Democratic Party people always win. Or maybe it's we follow the original meaning. Or we uphold the thing unless there's no theory of interpretation under which we wouldn't. That's an algorithm. That would be fine, and it would have the virtues of algorithms. It would have some vices, though, I think, in the sense that it would crush too many fixed points. But if I'm wrong on that, great. Go algorithmic. I don't think that the sole view of fallen humanity is going to map onto a continuous framework from the founding or after the Civil War to now. Can I give you some examples? Affirmative action falls. Commercial advertising triumphs. Campaign finance falls. Restrictions on presidential power to remove executive officers falls. The idea that those 4, and we could think of 100, falls out of humanity is fallen, soul is right, that would be surprising. But the things I've listed map onto the view of a political party, not on the view of 1880 or 1799 people. So that's concerning. Okay, Dick's points, I think, raise some fundamental things on which we agree, and then some fundamental things on which we might not agree, though to disagree with Professor Fallon is extremely foolish. So let's say provisional, tentative with fear and trembling, uncertainty, rather than disagreement. Okay, the idea, what would make our constitutional order better rather than worse? And thank you, Steve, for catching that on the book flap. The book flap also says that inside you can find an unreleased song by Taylor Swift, which it's not true. There is no such song inside the book. I would want to focus on human well-being in the constrained form of the actual book rather than the flap, and not on the word legitimacy. And I know Dick focuses and writes brilliantly on legitimacy. I tend to find, with the possible exception of Professor Fallon himself, the notion of legitimacy a rabbit's hole. And I'd rather focus, pragmatist style, on what makes human life better rather than worse. So the idea is you should seek reflective equilibrium for you. And yes, I'm talking to you, the particular person who's kind enough to be listening to these remarks. You should focus on what would make our constitutional order better rather than worse. And if legitimacy is part or all of that, great. I would hope that it would be what kind of lives are people living, something like that, which makes the flap not completely foolish, which is probably why I didn't catch it, but it's a more disciplined thing. It's constitutional law's version. What makes our order better than worse, not about, are people getting sick from a pandemic?
Professor, we do have another audience question.
Okay, great. I was just getting started.
Thank you very much. My question is about how the content and what you write about in the book affects the legislative process. So is there any way in which trends in interpretation of the Constitution change how judges write their opinions, how legislators write laws, or I guess an extreme version would be a new amendment to the Constitution that says everything up to now should be interpreted in the way in which it was written, or some like footnote that says we're all originalists now. Has that ever happened as a discourse around that?
Well, it wouldn't be binding. And so that if the Congress said that constitutional interpretation will take on board a certain theory of interpretation, the judges who thought that wrong would rightly strike it down unless their theory of interpretation was such that it was permissible. And that would be an unusual theory of interpretation. I think we got 9 votes saying that Congress can't specify the relevant theory of interpretation. An amendment of the Constitution could do that. And that is as likely as my making the Olympic basketball team. Don't laugh that hard. I'm tall.
We have another question.
Thank you. Thanks so much. I was wondering if you could speak a little bit about the difference between a moral reading and common good constitutionalism, because the way that I understand Professor Vermeule's theory, at least, is that common good constitutionalism is one moral reading. And if you disagree, why? And if you don't disagree, then why?
Okay,
Thanks.
okay, that's great. And for those of you for whom these categories are unfamiliar, Ronald Dworkin, I think now the most underrated legal theorist. He was at one point maybe very slightly overrated. He's now extremely underrated. Said that when you have a term like due process of law, you have to be faithful to it. You can't understand it to mean mackerel, but you make it into its best moral self. That's what you do. And that explains fidelity to text and moral reading. That explains what judges disagree about. And I think that's profoundly interesting and possibly true. Professor Vermeule's view is that Dworkin was right on the standpoint of method very roughly. He has a lot of appreciation of it, but that he was in the grip of a crude, thin, left-of-center moral theory. So the Dworkin had a bad moral theory, but methodologically he was somewhere between illuminating and clarifying and correct. So Professor Vermeule's view, he can speak for himself, is that the best approach is one that refers to a longstanding tradition of the common good, which doesn't mean that judges, let's say the best moral reading protects abortion. They consult the tradition, which isn't frozen, but which is not pro-abortion. It's the opposite. And so there's some methodological alliance, but on the Vermeule view, there's a common good tradition, which deserves admiration and fidelity, and that's better than making it up by reference to left of center stuff.
Thank you very much. Let's thank our panelists again.